There's an interesting decision there this week from the Court of Appeal to do with the question of the use of CCTV in a murder trial, and generally the use of CCTV by the Gardaí in relation to the investigation and prosecution of crime. This particular case involved a fellow called Philip Dunbar. He was sentenced to life in prison for the murder of a chap called Adam Muldoon. The Court of Appeal has delivered a ruling that the CCTV footage can be used as evidence in trials, stating that arguments against its use are misconceived, lacking in reality, and should not be used to take up valuable court time. The judge, Mr. Justice John Edwards, issued the ruling in the case of Philip Dunbar, who murdered a homeless man with a disability by stabbing him 183 times. He claimed that the use of CCTV in the prosecution of him for the murder was a breach of his rights under the Constitution and EU rights charters. Dozens of other trials have heard similar arguments, and the judge said on Tuesday that where such evidence exists, it would be a dereliction of duty if Gardaí did not access and use it to investigate crime and to secure convictions. The trial of Joseph Puska, the fellow who was charged with the murder of and convicted with the murder of Ashley Murphy, that judge, Mr. Justice Tony Hunt, said that he was fatigued by the familiar suite of arguments made by lawyers regarding the use of CCTV. He said a decision from the Court of Appeal was long overdue and pointed out that the arguments claiming that CCTV footage should be inadmissible had never succeeded in the Irish courts. So the Court of Appeal have issued a ruling there now in this Philip Dunbar case. In the Court of Appeal on Tuesday, Mr. Justice John Edwards said some of the arguments in the Dunbar trial and appeal were lacking in reality, and he noted that similar arguments had been made in other cases, sometimes at great length. In respect of arguments made under data protection laws, the judge said that processing of data such as CCTV footage was lawful where it was necessary and proportionate for the prevention, detection, investigation or prosecution of criminal offences. So data protection laws provide restrictions on the use of a person's personal data, including footage that might show their movements. That right was subject to necessary and proportionate restrictions for the purpose of the investigation and prosecution of criminal offences, the judge said. In other words, the rights that you have in respect of personal data are not unfettered, unconditional rights without boundaries. In the Dunbar case, the Philip Dunbar case, CCTV footage was obtained from private homes, local businesses and Dublin Bus. The purpose of having CCTV cameras, the judge said, was to protect premises, deter unauthorised entry, discourage antisocial and criminal behaviour, and to assist in apprehending anyone who did engage in such activities. The footage obtained was from public places, including footpaths, roads, a public park, a bus and the Square shopping centre in Tallaght. The judge says that it was not realistic to suggest that somebody walking or visiting such an area would have a reasonable expectation of privacy. While in some cases irrelevant CCTV footage was harvested by Gardaí, the judge said that this became apparent only with the benefit of hindsight. At an early stage of an investigation, Gardaí may well be acting under pressure, including time constraints, and a significant margin of appreciation must be afforded to Gardaí. Mr. Justice John Edwards said the court did not believe any of Dunbar's rights were breached, whether under the Constitution, the European Convention on Human Rights or the EU Charter of Fundamental Rights. He said that the challenge to the admissibility of the CCTV evidence was not made out and was quite simply misconceived. The CCTV evidence was highly relevant, and in any particular case, such evidence could be used to advance an investigation, to identify a suspect and provide relevant evidence at trial. In another case, he said it might even exonerate a suspect. He said the court had no hesitation in dismissing the grounds of appeal, adding valuable court time should not be taken up with such unmeritorious arguments. Dunbar was convicted of the murder of Adam Muldoon. He stabbed him, Dunbar was 17 at the time. He stabbed Mr. Muldoon 183 times in an unprovoked attack. And this fella was canvassing his data privacy rights in a bid to find that the conviction was unsound or unsafe or unconstitutional. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.